Welcome back to Passionate World Talk Radio Network, a wholly owned subsidiary of Global Media Network LLC. Educate, enlighten, entertain. And on today's episode of Lest We Forget History, we are going to go over the fact that our current president isn't the first president to confront the Supreme Court and then maybe back down. So, who was the first president who did that? Well, it happened back in 1832 when the U.S. Supreme Court heard a case, but the populist president didn't care. He had his national commitment to the Constitution, to morality, and to the rule of the law, his law. So, what really happened? However, this is the story about President Andrew Jackson in Worcester, Georgia. It was decided in 1832. And like the relationship between the president today and the court, the case dominated public debate, and it raised questions about the endurance of the rule of law. And at the height of the crisis, former President John Quincy Adams wrote, quote, "The Union is in the most imminent danger of dissolution." So what happened? Worcester, Georgia, had a dispute between the Cherokee Nation. And the treaties between the United States and the Cherokee Nation guaranteed that the tribal nation independence was on its reservation. But Georgia wanted the Cherokees to go away, particularly after gold was discovered on the Cherokees' reservation. In response to their refusal, Georgia passed laws asserting its control over the reservation, prohibiting the Cherokee government from meeting and posting guards over the gold mines. President Andrew Jackson did nothing to stop any of this violation of the Constitution and of the U.S. Cherokee Treaties. Instead, at the request of the governor, he removed federal troops, which were supposed to protect them, from the reservation. The Cherokees mounted a legal challenge and tried to take their case to the Supreme Court. Their lawyer, William Wirt, and the justices worried that President Andrew Jackson would not enforce a decision in favor of the Cherokees. Prejudice, bias, skin color? Oh no, the United States doesn't do things like that. Hell no. But Wirt told the court, quote, "What is the value of that government in which the decrees of its courts can be defied and mocked at with impunity? It is no government at all." Well, Chief Justice John Marshall ducked out, holding that the Supreme Court lacked jurisdiction over the case. Citizens against citizens. Who knew? And Georgia wasn't done attacking the sovereignty of the Cherokees. In 1830, Georgia demanded that non-Indians take a loyalty oath to Georgia before going on to the Cherokee reservation. Missionary Samuel Worcester and Eliza Butler, both pro-Cherokee and anti-slavery, refused to sign. The law made an exception for federal employees, and Worcester had served as a federal postmaster. But get this, Georgia persuaded influence the Jackson administration to dismiss Worcester so the exception would not apply. Talk about dirty politics. The case was argued in 1832, an election year, and Jackson's opponents campaigned on his disregard for the courts. Speeches at the National Republican Convention nominated the candidate Henry Clay to challenge Jackson, condemned Georgia's inhuman and unconstitutional outrages against the missionaries, and praised Jackson opponent Clay as a man who would assert the supremacy of the laws. For Chief Justice John Marshall, he was approaching the end of his career. The case in the election might decide whether his legacy in building a strong and independent Supreme Court would survive him. And Georgia, meanwhile, signaled its disdain for the court by refusing to even appear for oral argument in Worcester. The court's decision, 5-1, resoundingly vindicated the Cherokees. Federal treaties, the Chief Justice wrote, solemnly pledged the faith of the United States to protect Cherokee self-government. The Constitution made those treaties the supreme law of the land. Georgia's attempt to govern the reservation was repugnant to the Constitution, laws, and treaties of the United States. Guess what, folks? Georgia couldn't care less, and Jackson would not force it to release the missionaries. When the Georgia Guard jailed the Cherokees for celebrating the decision, Jackson wrote his brigadier general that the decision of the Supreme Court has fell stillborn. Newspapers across the country reported that Jackson refused to enforce the decision. That July, in vetoing another bill, Jackson declared that the court had no power over the president. The Chief Justice wrote, I yield slowly and reluctantly to the conviction that our Constitution cannot last. Food for thought, reminiscent of what's going on today. Dangerous repercussions. Perhaps our current president was channeling Jackson, his favorite president, when he tweeted that there would be a citizenship question on the census a week after the court ruled against his administration's attempt to add one. Certainly, the assertion was raised, as this president has, throughout his presidency, a threat to the constitutional balance of powers. But Jackson quickly realized that failing to enforce federal law in Worcester had dangerous repercussions. In December 1832, shortly after Jackson's re-election, South Carolina passed a nullification ordinance declaring federal tariffs illegal in the state. Jackson condemned them and supported a force bill that for the first time gave federal marshals clear power to enforce U.S. laws. If there was any doubt that federal officials could not force Georgia to release the missionaries, it was now gone. Rather than force a public confrontation, Jackson's allies went to the governor Lumpkin and persuaded him to pardon the missionaries still languishing in jail. The constitutional crisis was averted. However, it still didn't end well for the Cherokees. In 1835, while Cherokee Principal Chief John Ross was in Washington seeking protection from the U.S., Jackson's agents got individual Cherokees to sign a treaty agreeing to move to a new reservation west of the Mississippi. On the strength of that false treaty, the U.S. rounded up the Cherokee people and forced them west. The Trail of Tears, a forced march on which 1 in 4 Cherokees died, is a dark legacy. But today, Worcester versus Georgia also stands as a monument to both tribal sovereignty and judicial independence. At the height of the backlash against Brown versus Brown, Board of Education, Justice Hugo Black called Worcester one of Justin Marshall's most courageous and eloquent opinions, which, despite bitter criticizing and the defiance of Georgia, came to be accepted at law. But at what cost? The Trail of Tears? As Chief Justice John Roberts reluctantly joins the progressive minority on the court to reject political power grabs. It went through all the indigenous people. As soon as they found gold, they were gone. And as our current president agrees reluctantly to respect the court, at least in the case of the sentence, he follows in part that long ago legal victory of the Cherokee Nation, even though, like his predecessor, Jackson, he'll do what he wants, not what the Constitution demands. Thank you very much for listening to this episode of Lest We Forget History. Please go over to passionateworldtalkradio.com/blog, listen to the podcast, read the summary, and please go to the URL that we provided, click on it, and read the whole story and pay attention. And if you want to keep the lights on, the heat running, and the AC working for this summer, and continue to hear the truth, the whole truth, and nothing but the truth, so help you to a spineless piece of dill pickle, please go over to passionateworldtalkradio.com/donations and donate $5. Thank you very much and have an awesome weekend.